Division bench item 1.
Matter was already heard, and it was decided that the people will be convicted, the accused persons. Now it was sent for sentencing. And before sentencing the accused persons, the acquitted accused persons, the case was remanded for sentence hearing. And I think, of course, it was done. Perhaps a report has come, but not required under the law. My comments on it.
Just a moment. Appellate stage sentence hearing.
Section 386.
Yeah, is required.
One sentence, further inquiry, but not sentence hearing.
Rajan, and to your Samisaran, a query. You see, once it's an offense under 302, and the appellate court is inclined to convict the accused. Under that circumstances, there are two options only, either death or life. Now, so far as subject to correction, so far as I understand, or I recollect, in fact, is that once it's a case of acquittal which is converted into life, which is converted into a conviction, then death is normally not given. That's a thumb rule. But in exceptional cases, death can still be ordered. But as a thumb rule, once it's a case of acquittal converted into conviction, then, as I understand, subject to correction is that thumb rule is not death, so life. So once it's a case of life sentence only, do we have to hear the accused person? Brother has one more query.
No. No.
What is your opinion?
The order of the.
No, because you have added advantage. You are both here and there. That is a rare combination.
Sentence hearing is there, but the learned council, the hearing body, accused persons are also not present.
The councils are not there, they have filed their color count. They were heard.
They will have.
No, at that time, that point of time, they were heard. But uh, what do you think of the proposition I'm saying? Is it a correct thought process?
Without sentence hearing.
Yes,
In fact, 386 doesn't provide for any sentence hearing.
386.
So, yeah. But there is a term used as directing any further inquiry, but after perusing, logic got 386.
Yes.
After perusing such record and hearing the applicant or his pleader, if he appears, and the public prosecutor if he appears, and in the case of appeal, under 378, the accused, if he appears, the appellate court, if it considers that there is no sufficient ground for interfering, dismiss the appeal, or may, in an appeal from an order of acquittal, reverse such order and direct that further inquiry be made, or that the accused be retried or committed for trial, as the case may be, or find him guilty and pass sentence on him according to law. I think the last sentence will come. First sentence, of course, it says in an appeal from an order of acquittal, reverse such order. And direct that further inquiry be made. Now, what kind of further inquiry is, I cannot say now.
No, because that the power of the appellate court is always there. We can say for further evidence, for further trial or further hearing from a particular stage. That there is extensive power we have. That is one part. Second part is
It may be retried or committed for trial. And the third part, they say, find him guilty and pass it.
and pass the sentence. Sentence is only life. Because
Rare circumstances.
that is not even from this. It does not appear from the circumstance that as a state had preferred an appeal saying that the sentence it will be sentence and sentenced to death. That is not even the case of the state. We'll ask for a scroll, Mr. F.K.R. Ahmed, appellant advocates, respondent advocates. F.K.R. Ahmed and Mr. J. Uddin. We'll wait for some time. We'll wait for some time, Mr. Alam. Mr. Alam, there's one more query. Uh, we are just thinking aloud. We are not formulated our mind. We are just thinking aloud. Number one, the division bench, while passing the order of conviction, I said that the district judge will make an inquiry and take evidence if required. Or they will hear the accused for sentence hearing and then take evidence if required. Now, we were just discussing, in our mind, the first blush, it appears that when there are mitigating circumstances available, which did not come out in trial, perhaps at that stage, even at this, in that case, even at the stage of sentence hearing, accused has a right to bring out the mitigating circumstances for a lesser sentence, and then evidence is required to be recorded. Correct. Now, in this case, the order of setting aside conviction has been done by the High Court. Now, if we are not speaking of this case right now, let us say that I send it back to the district judge, or sorry, session judge, to hear him on sentence. A query of ours is whether a session judge can impose a sentence. No, he can't impose a sentence. Now, if we now take it up, there's another issue which comes up in a criminal trial, is that the court does not have a power of review. Number one. Number two, there is also another set of well-established principles which have been decided by Supreme Court all throughout, that if a court has otherwise jurisdiction and there is an error in the order, even a criminal court inherently can visit the order, because if it lead to illegality. Here, sentence can't be passed by a sessions court, because the appellate court has given a judgment. So sentence can't be delegated to others. So it will just record the evidence and send it back. Now, we can't impose a sentence below life. So therefore, that is the minimum sentence we can impose. Now, this, do you think we should do it on our own, or we should refer it to a larger bench for propriety of the orders? What do you think?
The Lordship has rightly referred that there may be some mitigating circumstances, and in that order present only, the sentence hearing is only required only for that reason, because the 313 statement will be required. Whatever evidence has been recorded against these accused persons or only, it will be placed before them, pointedly asked to them what explanation they have to give. If they give some reasonable explanation, justified explanation, the court may consider that yes, there are some circumstances which go in favor of the accused persons. Suppose provocation, other things. And in that case, what about the learned court below will ask them whether they are going to adduce any evidence in support of their case. If they are at liberty to examine any witness, they can examine themselves also, or other witnesses also. And all these materials will be considered by the court for passing. But in this case, whatever, only materials to be recorded and sent to this honorable court, because honorable court has sent it to the sessions court only for recording purposes. That consideration will be done by this honorable court, because passing of the sentence will be done by this court. It is not left to the learned court. That is the difference. Honorable court may consider all these materials if it has already been recorded and sent to this.
But we can't reduce the sentence to minimum.
Then just record this justification that those such materials have come forward under the provisions of as the accuser convicted under section 302. There is no lesser sentence provided under this section, and the whatever circumstances they have pointed out, which may be regarded by them as, or they have put forward as mitigating circumstances, that does not justify reducing the sentence or altering the sentence from 2030 to any other provision. And that justification will be containing the explanation put by the accused person or convicts. That will be on record.
No, but you see, sending the matter back to trial court, recording of all their evidences, it will take a year.
No, but what I want to add just one thing. Suppose this accused person convicts wants to go to Honorable Supreme Court.
He can't go right now because there is no
No.
sentence. Against the judgment and sentence has to go.
What about-
Sentence is not even given because you see the right in it.
Yeah, after
No,
sentence.
no, Mr. Anand, I'll just tell you. You see, insofar as what I have read subject to correction, is that there are a lot of decisions by the Supreme Court of India, including one which is authored by a three-judge bench where Justice Bopana was there. It has been held that once acquittal is reversed to a sentence, which is either death or life, then one has a right to go to Supreme Court, the Article 134. They have referred. Now, if the sentence is less than 10 years, then inherent right of appeal is not there. They can go in appeal, but that will be again not a what you call a constitutional right, which they will be availing. It will be leave to special appeal, and it will be the discretion of the court to entertain appeal or not. So this is a distinction which is drawn by the Supreme Court of India. That is one part. So therefore, if it is only life, for the time being, we are omitting death. Let us say if it is only life, then why send 10 people back to the trial court, have their evidence taken? Evidence, we all know how much time it takes. We don't have to comment on that. And after a year, when it comes back, we give a sentence which we can give it right now. That's why we are asking.
Because that's what I have placed. Because the accused and convict, they will have some satisfaction. They are able to explain their, because for this time, it has not been placed before. This opportunity has not been given.
Mr. Adam, we find your submissions very practical and appropriate. But we were just discussing, there's another viewpoint of same thing. Life is again a discretion of the sentencing court as to what would constitute life. Life without remission, life 14 years, life subject to maximum 20 years. So whatever is that, it's a discretion. Now let us say that under the facts which are available on record, we think it's only a proposition. We are not making up our mind, but we are trying to say that, let us say we feel that, assuming that we feel that we give a minimum of sentence prescribed, Minimum sentence is life. Now, whatever is the interpretation of the state they will do, we say life. Now, under that circumstances, when the minimum punishment is life, question of mitigating circumstances is non-est to be considered, because that is the minimum sentence we are awarding, not the maximum sentence. Therefore, mitigating circumstances would only justify a minimum sentence or reduction of sentence which we can't we can't go below life. So you see, their satisfaction of explaining to the court their circumstances would be otherwise not necessary.
There is a difference between 313 and sentence here. So any mitigating circumstances, the accused will bring forth in 313 statement before conviction.
No, because you see what had happened was, since the order of acquittal was there, Mr. Adams' submission is right. Because he would have got an opportunity of addressing the court on sentence hearing. And that itself is a mitigating circumstance, and for that, evidence is permissible. There's no doubt about it. Now, so far that is concerned, we say that his approach is absolutely correct. But this is circumstances which we are now urging is that, you see, the state is not in appeal. Therefore, question of sentence, insofar as state is concerned, is not under challenge. The acquittal is not under challenge by the state. Now, the informant side has filed an appeal, and he has been successful. Mr. Alam has been successful in convincing the court that this was a case where the acquittal of 10 people were wrong, and therefore they have been sentenced. They have been convicted, but not sentenced. That's why we are asking on the question of sentence that if let us assume or presume for the time being that we are thinking aloud that we may impose a sentence which is minimum, and minimum is life. Now, in that, let us say that evidence is recorded for all these 10 people. Mitigating circumstances come on record. Can I go below life even for a day? I can't.
Conviction is under
Huh. So here I am saying in singular, I am not saying for my brother, because we are not formally decided. So I am on singular right now.
If fixed the thing, that this is for their only opportunity they have availed, that mitigating circumstances is related to the minimum of life sentence. Suppose 20 years or even.
So even without that,
Satisfaction to say that, yes, we have explained, product in honorable court is pleased to award us the minimum sentence, that is just life sentence.
you see, there's another circumstances why we are.
To pass any order, I am.
No, not that. You see, since you are assisting the court, we are trying to ask you. Yes. Since you are assisting the court, we are asking those questions.
Because my only point is, let them be convicted or acquitted, but they must have a chance to speak out that, yes, we are convicted, we have got this thing to say. During trial, these materials could not be brought to they are brought before the honorable court. Now we are, because we are going to be convicted or convicted. For that reason, these are the circumstances.
No, conviction is already there, not going to be convicted. He is already convicted. It's only a question of sentence. That is one. Second is that, you see, you got a order of reversal in 2021.
Yes.
Now we are in 2024, 3 years gone by. Now, if these 3 years are gone by, now if we weigh this on the scale of injustice,
Yes.
then you will come and say that, yes, I am suffering injustice because there has been a conviction, their sentence is not being imposed.
Lordship has heard all of them. Any mitigating circumstance, Lordship will come to know from them. They need not be heard for again sentencing. Sentence hearing. Because sentence hearing was not done because they were acquitted. After 313, judgment was pronounced and they were acquitted. So sentence hearing stage they did not reach. Now Lordship has heard them here. It's
They were-
not that
they-
they were not heard.
They were heard through a lawyer. No, there's a difference. That's what Mr. Alam is saying. There's a difference. Mr. Alam is trying to justify that since sentence hearing is not there, they will have a satisfaction of having their say before sentencing. That's what he's urging, and it's fair submission.
Provided enhancement of sentence by state.
That's why we are asking you.
Person has
Now, can we revisit that order? It would amount to review or it's amount to correction of the order and we can take it up without referring to a larger bench.
Larger, there have been conflicting judgments and all now. Here, point lordship can decide without referring. When there are conflicting decisions, when there are.
It's not a question of conflicting. There is already a verdict on record. Now we are saying that this verdict be diluted. And diluted in what sense? That the order which has been, which is there to the Lanad District Session Judge to hear the one sentence should be altered and we pass the sentence under 389 as the court is empowered to do it. So whether that would amount to review.
That we perhaps done in presence of the.
So we're just thinking aloud. He's not there. We are given a scroll for him.
If he is present, then honorable court will pass it, because hearing him also amounts to hearing the.
Correct.
That may be passed, he will be informed that he should be present tomorrow or day after.
That's what I said, the lordship can hear this. one. Same things.
Okay, just give a scroll for FKR Ahmed. You're given. Okay, we'll take it up after some time. Okay, we'll take it up after some time. If you are busy elsewhere, you may go. We'll just hear Mr. Ahmed and then.
I'll take care of it.
I think so. In this case, Mr. Ahmed will argue this case. There is some personal difficulty in first of all. I pray also may take after some time.
Second half.
And- Okay.
Yes, Mr. Deka, your matter now.
My appellant here, he has passed away, Ram Naresh Chauhan,
Is it?
around 15-20 days back.
Oh. So,
The aged person, my lord, on that ground, he was also granted bail. At the time of passing the judgment, he was around 85.
okay, so we'll have to make an inquiry to
Because
the jurisdictional police station then.
Because it's a big.
He's on bail.
Other than that, it's a big, right?
He's in bail.
around 15-20 days back, he has passed away.
Oh, okay. His family members have informed you.
My lord, because we came into contact because of the bail petition.
No, it's understand.
The
It's
son
okay.
had called me up. Yes.
Okay,
In fact, I had sent a message.
okay. Because we'll record that and then
Fine.
just see, right?
Photographs were sent of the dead body, my lord, but
No, I
no-
understand.
no documents have been.
I understand.
Had there been a death certificate, my lord, I could have produced it.
This is Karbi Anglong. Which police station? Kheroni. Page 5. Paper book. Paper book at page 5. Kheroni police station. Just gives this IA. Yes, Kheroni. Right, Mr. N. Deka. Learned amicus curiae, appearing for the appellant. has submitted that yesterday, I on 22/1/2024, he has received information from Harinath Chauhan, Harinath Chauhan, Chauhan.
It was someone, Ramesh or someone.
Okay, not, okay,
Not mentioned, he said the sample.
okay. From a family member of the appellant,
Parmeshwar Chauhan,
Parmeshwar, okay, Parmeshwar Chauhan.
the affidavit of the I. The bail, I criminal 292.
Okay. Parmeshwar Chauhan.
May I hand over the copy?
No, it's okay. We'll take it.
Parmeshwar Chauhan.
Son of Lakshman,
Not
LAK.
Lakshman, son of Ram Naresh Chauhan. Lakshman is the second case.
Oh, okay, Ram Naresh
Ram Naresh is first.
Chaudhary,
Chauhan. There is a typing mistake in the
paper book. Acha, okay. Son of Ram Naresh Chauhan, Chouhan, appellant in criminal appeal jail number 448 of 2019, to the effect that about 2 weeks back, the said appellant, namely Nam Naresh Chauhan, has expired. Just give me that the memo appeal, second appeal. Next para. It appears from the memo appeal that the said appellant Ram Naresh Chauhan is a resident of Shankar Basti, SANKAR, Shankar Basti, under Kheroni PS, KHERONI PS in the district of Karbi Anglong. So accordingly, we deem it appropriate that an inquiry be made through the officer in charge of Kheroni Police Station to inquire as to whether appellant, namely Ram Naresh Chauhan, has expired or not, and a report thereof is sent to this court. Next para, the Ms. S. Jahan London APP shall send a downloaded copy of this order to the Kheroni Police Station, so as to enable the officer in charge of the said police station to make an inquiry and to submit his report before this court prior to the next date of listing. Next para, list on when 2 weeks, okay. 12 to 2024. Next paragraph. Before that, in view of this matter stands adjourned today. Based on,
Other matter perhaps also get adjourned.
yes, because it's, we have to have a common hearing. Then you correct that sentence, huh? After that, the list on so and so. Okay. Okay, you just write the names, Mr. D.K. Bhattacharya, in criminal appeal 296 of 19, recorded presence. And there's only 2 matters. Oh, okay, this on so and so is also present. Just add there. Okay. Yes, Mr. Prasad. Yes. Item 5, LCR. Give it to her. It appears this matter was heard earlier.
By different,
Hmm?
by different.
I understand.
I'm challenging the judgment and order in special POCSO case number 4 of 2018, for which I have been convicted under section 4 of the POCSO Act and sentenced to undergo imprisonment for life. To pay a fine of rupees 10,000 in default, to pay a fine of 200 further imprisonment for 6 months.
What is the sentence imposed?
For life.
Hmm?
It's imprisonment for life.
Life.
Paragraph 48, page 42.
Yes.
But the FIR was lodged on 24/4/2018. So before I begin, I'd like to place that the provisions of section 4 has been amended in 2019. So in the instant case, the old law will be applicable. I've already submitted a gazette notification of 2019.
Yes.
The last page you wrote,
Yes.
16th of August 2009.
Yes.
In exercise of our so and so, the Protection of Sexual Offenders Amendment Act 2019 hereby appoint 16th of August 2019 as the date on which the state act shall come into force. In
Yes.
2019, the punishment has been cancelled. So in my case, the previous law will be applicable.
But that is also life. Under section 4.
Maximum was 5,
Huh.
minimum was 7 years. 7 to life.
7 to life.
So now it is 10 or 20 to life.
Okay.
There are two different levels.
Okay.
If I may place the FIR, madam, page 1.
Yes.
FIR is of 24/4/2018, lost by the mother of the victim. The victim is my daughter. The FIR Azhar is at page 4, madam, exhibit 3. Page 4.
Yes.
With due respect, I beg to inform you that so and so is my daughter. Now I reside at my father's house because my husband, the appellant, assaulted me and drove me away from the house 1 year ago. And my 11-year-old minor daughter, Miss So and so, stayed with my husband at his house, situated at Bhakti. The Lord will mark that Bhakti place. But yesterday, my daughter fled to her maternal uncle's house, situated at Parsala Gaon. And from here, we came to know, from how we came to know that my husband, the appellant, has been committing rape forcibly on my 11-year-old minor daughter regularly for the last 6 months, and she fled to save herself. I therefore pray to you to take necessary steps against the appellant by investigating. It would reflect from the order sheet that I was arrested on the next day on 24/4/2008. And since then, I'm in jail.
Yes.
This was investigated and the charge sheet was filed within a period of 1 month, 7 days, madam. The charge sheet is at page 57. On 31/5/2018, the charge sheet is filed.
Yes, please continue.
I would like to place the second paragraph of the charge sheet at page 60. In course of investigation, the place of occurrence was visited. I'd like to Lordship to mark this question. The place of occurrence was visited and the witnesses were interrogated, medical examination of the victim got done and medical report was collected. During the investigation, this case is found to be well established against the appellant. Therefore, the charge sheet is being submitted to the Honorable Court for trial against the appellant, so and so, under section 4 of the POCSO Act. Witnesses need to recall so and so. After the charge was framed, the charge is at page 6 of the report. Page 6.
Continue.
The charge was framed under one head that since last 1 year at the interval at intervals at Uttar Bangti village under Patasar Kuchi, you committed penetrative sexual assault to the victim, who is your own daughter, inside your house, and thereby committed an offense punishable under section 4 of the POCSO Act within my competence. So the place was Uttar Bangti, my lord. The victim was, her evidence was taken as PW1, madam. Our evidence is at page 9, madam.
Yes, please continue.
I,
Oh. The AOJ Criminal Appeal Section shall serialize the record and send the records back to the court of the next date of listing, list on, make it Friday.
Friday the 26th,
Oh, no, then it will be next week,
29 of Friday.
29th. Okay. There's a difficulty. The original records are not here. Supreme Court has given a direction. High Court records have gone back there. Now, in the meanwhile, we have given a direction earlier to that, to the district judge, to the Sessions Court to hold to take evidence. Some inquiry was made by the district judge, he has sent some records. So we have asked the registry to make the file in serial order and send it to us. We have told them what we want actually. So if that comes then on Monday next, please be here because we'll take a call on that, what do you call the further evidence if required for sentence hearing. That we will examine if it can be revisited by us. That is one. Second is whether you will also address us on the point that whether such an order would amount to a review of the earlier order, and would it be appropriate for us to take it up, or it should be referred to a larger bench and then this order be recalled? Because this is with a rider to the effect that we are assuming for the time being that the sentence would be minimum sentence which can be given. But we can't say that. If the circumstances are so that we can, even if we find that that sentence can be ordered, then that inquiry will go on. Correct? So this is something which we'll have to address. And also, if it is possible, because we'll get 2 or 3 days time, try to get a judgment, because I recollect order of the judgment of the Supreme Court where it says that if the acquittal is reversed and it amounts to a conviction, then normally a death sentence should not be granted. Only that much. Correct. Yes,
Saying main parliament.
main pal.
Paragraph 20. Here on the illustration of
Daily list item 1 for delivery of order. BA 7/24.
You got the list of citations they have relied on. You have not given it to them. If you don't give copies, we can't hear ex parte. They relied on certain citations, because you must get an opportunity to meet that. Give me a list at least. Give me a list, because you see, we permitted you to give it to the courtmaster. That means that he has to have a knowledge of what is being transpired. He has a right to know it, correct? Next time when you give anything to the courtmaster in connection with the matter, other side has a right to get it, huh? Because he may differentiate it, because otherwise, because then I'll not be able to pass an order today. When do you want? No, because day after tomorrow, then? Or Monday? Day after?
I'm here.
No, I'm giving, you see, you have a liberty to tell us.
You can put it on, because Friday is a holiday, so Monday is.
Monday, okay. No, you give it as many as you want, but you see, please give it to the other side also. Make out a list. You take this back, make a list and give it to him right now. Mr. Y.S. Manand, and counsel for the petitioner, as well as Miss M. Deka. The counsel appearing on behalf of standing counsel DRI are present. First of all, the Learned Standing Counsel for the respondent has referred to some case citations. Mr. However, a list thereof has not been provided to the Learned Counsel for the petitioner. Mr. Let a list of those cases be provided to him in course of the day. So delivery of orders has to be adjourned. There had to be adjourned for the reasons mentioned above. List on 29/1/2024. Should I say for reply? Because then I'll pass orders on the same day for reply by the Learned Counsel for the petitioner. Okay, then I dictate there and there.
December করে রেখে দিবেন।
নাই
না, না, section.
আচ্ছা করে দিয়ে দিও হ্যাঁ
Oh, sorry.
ডেটটা চেক করে দিয়ে দিও Yes, item 2
No, এই supply আছে।
supply. Okay.
Supply item 6.
Here, my lord, one query was raised on the last occasion, my lord, because this is the second bail application.
Yes.
Earlier case, my lord, I was granted interim. And the landed PG has submitted that I had not appeared. But my instruction
yes,
is
yes,
that, my
yes.
lord, that interim order was passed, my lord, the date may be important, my lord. The interim order was passed on 12/4/23. Interim order dated 12/4/23, passed in AB number 1043 of 23. Thereafter, my lord, I applied for the copy and I got the copy and I appeared before the IO on 15/04/23. And the name of the IO is, my lord, Miral Ahmed, MIREL Ahmed. But my statement was not right. I have submitted my, the original certificate copy.
Okay.
Now, my lord, who is the IO that has to be confirmed? My instruction is the IO had transferred.
Can you find out?
Because from the FIR, it seems, my lord, the IO is Mirala. And now who is the IO that can be confirmed by her? my lord? FIR তো নামে আছে। ইতিহাস কি নাম? 15
Because Ms. Baha, this has some this inquiry is required for another purpose also. You see, what is happening is that this is not the first case when I in dealing in bail that we have received a complaint that the IO did not record the presence, and therefore in court it is presented as if the IO, the accused, after getting an interim bail, did not appear. This is not the first instance. Because if that is there, we'll have to take up even suo motu proceedings, and then we'll have to make things in, we'll have to bring things in order. We'll have to take cognizance of these complaints by the citizens saying that they, after receipt of bail, grant of interim bail, when they approach before the IO, they don't record their presence.
Give us a chance to let us write.
No, do it because no, it's not a question of IO. You see, this IO is something everybody will be able to know that he is the IO XYZ. We are not saying that what Mr. Datta is saying is absolutely sacrosanct. I'm not that. But the fact is that if he has appeared before the IO and they don't record this, there is something which is affecting the administration of justice, and therefore we'll take up so much of cognizance of this and have it rectified.
I can file an affidavit in the next, if required.
Please do it because you see,
Fine.
it's not only for this case.
Fine.
It affects the administration of justice because I have faith on the lawyers. You make a statement that you have gone there, and then the PP comes, says that no, this it's not there. We even have faith on you. We don't disbelieve the system. So therefore, we have to arrive at the truth.
Or should we fix it on Monday, my lord? By this time, I'll file an affidavit.
Okay. Mr. Anjit Atal and counsel for the petitioners has submitted that he has obtained specific instructions to the effect that on grant of interim bail by order dated 12/4/2023 in BA, AB 1043 of 2023, the petitioners had appeared before the IO, namely Miral, MIREL, Miral Ahmed, and handed over to him a certified copy of the and on 15/4/2023, a certified copy of the order of interim bail was handed over to him. Mr. However, he submits that he is not aware if the presence of the appearance of the petitioner before the petitioners before the IO has been recorded or not. First off, in this connection, Ms. S.H. Baral and APP submits that as per her instructions, the on grant of interim bail to the petitioner.
Sorry to interrupt, Malad. Here, Malad, the point arose, Malad. Last occasion, she had submitted a report before your lordship, Malad. In that report, Malad, who is the IO, Malad? Who has given that report, Malad, that he has not declared? That is still.
Oh, acha. No, now something else, different IO.
Yes, Malad, that's the point.
Acha, okay. You change it, huh? The APP has submitted that as per the forwarding report, as per the communication received from the IO, the appearance of the petitioners before the IO pursuant to interim bail granted on 12/4/2023 is not recorded. First, next, in this connection, the learned counsel for the petitioners has submitted that during the pendency of investigation, the IO has changed. And perhaps the appearance of the petitioners before the earlier IO has not been recorded. Next paragraph. As the court finds that if the statement made by the learned counsel for the petitioner is correct, that after grant of interim bail by order dated 12/4/2023 in AB 1043 of 2023, the petitioners that appeared before the IO, but their presence was not recorded, has to be investigated. It has to be examined. According to the London APP, shall put up a specific query with the IO as to whether there is any material on record in the case diary showing handing over of the order of interim bail granted by order dated 12/4/2023 in PA 1043 of 2023. Insofar as the interim bill of 12/4/23, it's there on record.
Yes.
This bail order is there on record. Is there? Below this PMR flag, 1 or 2 pages below that. Is there?
Because I have filed the application date maybe. And comparing, it is same as this. I have obtained. I have given.
No, I'm saying I don't disbelieve when you're making the statement, we're not disbelieving you, but
That's satisfied.
we have to go by the record. Then perhaps we'll extend that order, extend bill to him.
No, but it's a second bail application. Let me appear before the IO and record my statement, then your lordship will.
It was rejected.
Therefore, it was rejected.
Right.
That Pharmacy case, madam,
No, no, correct, I remember it.
Thereafter, it was rejected.
No, correct, but still we can
Yes.
revisit that order and grant him bail.
Fine.
We told you in these cases what has happened. It's only because more than a year has gone by. No investigation is progressing. Just because of that lack of bail. And once he has appeared, the IO could have recorded his statement and then end of the matter, what has happened. His appearance is recorded. Just tell me what is it?
It was granted on 12/4/2023. Thereafter, there is a note. The stated is the 2023.
Marking good. Yes, please. No. This is reflected here. One person called Sufiur Rahman, having mobile number 98543 45833. He appeared before the IO, gave a copy of this bail order, and says that পৰৱৰ্তী সময়ত পদকীয়াই থানাত হাজিৰ হ'ব।
Can I leave it to your lordship? I have nothing to say, madam, because the order, the interim order was there. My instruction was that he appeared, madam. So in that case, my lordship may, now if your lordship gives him an interim, madam, let him appear and record his statement. For a few days, madam, at least, madam, let him appear. I will cooperate this time.
Because you see, then you'll have to file some affidavit saying that why you could not appear on that day. Because extension can't be made of that earlier bail order now.
Yes,
in the second application. Or we allow you to withdraw this and file a fresh one.
For the last chance, one, I'll take an instruction, madam.
Okay.
Why why he did not appear, whether he had appeared, then what?
Then don't say all things. You just repeat the last order again.
I'll file it next week.
Mr. N.G. Dattar and counsel for the petitioners pray for further opportunity to obtain updated instructions. So Ms. S.H. Baral under APP is ready with the case diary. List on 29/1/2024. Let the case diary be written till then.
I'm okay.
This section of application, the CD.
CD. Take the CD or we should keep it. Okay. Okay.
No.
Yes, Mr. Agarwal, your matter.
For my submissions have been concerned. No, it was concluded.
Yes. Without the SM blue diary. Nigga. Okay. Okay. A very difficult changeover.
Huh?
A very difficult changeover from IPC, CRPC to CPC.
I have not seen it.
Huh?
This new IPC, CRPC.
No. I said that from IPC, CRPC to CPC, to jump into CPC is a difficult change.
Already we are 4 but also.
It's a difficult change.
Lordship will hear because hardly for a few minutes it will be heard and thereafter again Lordship has to be met.
No, because you see, this few days I am assigned with this criminal bench. So I've got no option.
No, I understood. I'm
You see, the difficulty is that if I don't hear it, then I have to recuse it.
Yes.
That gives you more difficult situation because you have heard, because you have spent your time and energy.
True. That's true.
Your live stream can be made open. Live streaming can be made open. Okay. Because in POXO matters, you'll have to close it.
My submission was that, since we challenged.
Your part is almost concluded.
Yes.
Ah.
But it's-
So is there any reply you can?
Let me start.
Ah.
Not the I may have some case laws, not the,
In reply, you can present that,
that's what I'm saying.
or if you can
But
give the,
basically, my lord, one question was there, whether it should be a remand under order 41/123A or whether it is remand under order 41/125. Because, my lord, the judgment was set aside, my lord may kindly recollect. And then it was sent. Then my lord says that sometimes it happens. Because if it is not set aside, then he will not be able to pass the order, the trial court.
yes. So because then it becomes an order of remand under 23A. Then it becomes an order of remand under 23A.
But my submission was that, my lord, that since it was set aside and remanded, at the same time, my lord, the direction was that you decide the issue and then send the record back to me. The
You're
update
saying
process.
it is within the meaning of,
Your lordship kindly.
because then it would be order under 20, it would be a case of 25 then. When appellate court may frame issues and refer them to trial.
So this is a
But,
bit wrong.
but that is not happened.
That is not happened.
We accept your point because that's a point we'll have to decide whether only one issue could have been decided after setting aside of the order,
That is the basic,
Huh.
my son, whether it could be.
whether it could be.
Once it is set aside, it goes. The entire judgment goes.
Yes,
But at the same time, the direction was that you decide on this issue and send back the report to the appellate.
no, you see, that is one part. The the other question, which is a corollary question, would be that if there's no objection from either side to that, and if the court decides only one issue, the question is whether you suffer prejudice because of that. And technically, what happens is that, let us say in a given case, a matter has been remanded for a fresh decision on a point which is already there is an evidence on record. Now, the trial court takes up those issues afresh, examines the evidence afresh, and arrives at the same finding. Then what?
So that is a judgment after remand, my lord, definitely. The lord, the trial court can come to the same conclusion.
It can come to the same conclusion. So therefore,
There is no difficulty.
but yes, you are right. This question
Because, my lord,
will haunt us.
Question is not that, my lord. My lord is saying that, my lord, the matter is set aside, remanded back, he has decided.
But there
this
has to be a fresh decision on all the issues. That is the
That
question.
is-
Okay, we take notice of that.
My lord, that
You can give the citation to Mr. Sharma also. He can
my lord, I'll give a.
he can at least
He will-
give
he'll
give an effective reply to that.
Yes, I'll give. Today itself. And on the point of burden of proof, so the trial court says that it was your burden to prove that he does not have an authority or right title and interest to sell. Kafratullah has no right title and interest to sell to the plaintiff.
Yes,
The trial court, the appellate court finding is that burden of proof is on you, not on the plaintiff to prove it.
you are the plaintiff.
I'm the defendant.
You are the defendant.
So I'll give the decision so that my lord, my friend can come prepared in the next day to answer to that.
Okay. Yes, Mr. Sharma. Just a moment. Mr. Agarwal, it appears that last time I made a mistake, I perhaps. In your summing up, I have made a note on issue number 4. Whether the plaintiff has right title interest over the suit land. You have referred to page 55 of the first appellate judgment. And then you are referring to. But thereafter, I did not write the conclusion. What was the submission? I did not record. You just referred to page 55.
55, I'll come again.
In my notes, I perhaps have, I did lost the track.
Page 55, issue number 4.
But your submission, I failed to record.
Now, here it says that I have found that the appellate failed to prove this fact by adducing evidence.
Oh, same question, whether the burden of proof was on you. That is what you are,
Yes.
oh, okay.
And then second district, at this point, I agree with the submission of the learned counsel for the respondent that the appellant never disputed the factum of sale of the suit and by Kapitullah to the respondent. That was my lord has also taken note of the. Exhibit 1 is the sale deed. As the sale deed has not been denied, I have reason to hold that the sale has been admitted by the appeal. That is registered sale deed, and by virtue of section 4 of the transfer title over the suit land legally transferred to the respondent. My submission was that from the very initial stage, in the written statement, my stand was that the Kapitullah did not have any right title in interest over the land. First thing, the burden of proof. Secondly, it says that since sale is admitted, the sale deed is there, my lord. I'm not saying that sale deed is not there. A sale deed has been produced. Our case is that it is.
No, because then you see, since I'm forgetting the track, since I did not record, I have forgotten the track. I'm just asking you, if you take a plea as a defendant that that Kapitullah did not have the right title interest to transfer it, then it becomes your burden to prove it. First burden would be on you. It is only thereafter the onus will shift on them when you can successfully show that he did not have title, because for that you are referring to the Jamabandi.
They claim. Their claim is that the Kapitullah has right title interest, and accordingly he made the sale deed in my favor. And right.
So yours is a plea of denial.
Have a plea of denial.
Okay.
That's what I'm saying. They have to prove first. And in the evidence, my lord will kindly see neither the Kapitullah's signature was proved, nor the witnesses, though they appeared, they say that we are the witnesses to the sale deed, their signature has not been proved.
Okay.
And another aspect was that so far the handing over the position is concerned. We have denied that we are from position from before the sale deed was made. And in fact, we are the legal heirs of the original Pattadar.
Yes.
In this context, my submission is that the Appellate Court came to an erroneous finding The sale has been admitted. You know, the question of sale being admitted or not admitted, I am saying that, he does not have the right title and interest.
Yes.
The entire course of land. There is no. Title. Now. Put a land tag to the past. I mean,
This Nur Muhammad gifted his entire land to 5 sons.
purchase the land of it. But the same from Boliram. Same plot of land, Boliram.
Just a moment. Plenty purchased the land from Kaifatullah. Kaifatullah purchased it from Boliram Bora.
Purchased from Asra. So is the one of the sample.
Purchased from son of Nur Muhammad.
Legally was one of the brothers. So for the mutation participants. Name of Nur Muhammad was there. His name was on account of land. So all these 5 brothers' names have been mutated in the next, and have been recorded in the next. For their names in the records of where you have no biology. They have a history. And what is among the 5 brothers? First sale was made. Typically by Sunpur to Malik, unbrother to another, in respect of the Sultan. And there was Sultan. First sale to outsiders. The person from the other. Ashraf Ali first sale. So, portion of the Sultan to Boliram. That is recorded. That
First is inter-party sale. What is the sale? What is the time period?
1978.
1978.
11 for 1978.
Who sold?
Ashok.
How much land?
10. 14.
14. To Cafetullah.
Boliram to Kabe.
Yes.
Twenty-six by 1977.
26/5, 1977. 26/5, 1977.
School to Boliram.
Hmm.
Right? Very good. After his name has been recorded in the record. That is also in I don't know. Give me two. This thing.
Yes, page 10 of. Paper book. What, where is original gone? Ah. Exhibit 2, yes.
Down. Fifteen.
Yes.
Then.
Yes, entry number.
And the.
Just a minute. Yes. Yes.
page number 51, the same document has been realized upon by Puntabar.
Page number
51. The lady.
51. Yes.
Tabor Dagon Nika Mawasa. For Ali Kai, Koida, money, the meaning of the number. And উপকৃত সমানতা আর বিশ্বাস পদ্ধতি টাইপৰ মতে পদ্ধতি ডাগৰ এক কথা সূৰ্যলেচা মাটি শাস্ত্ৰ পানীৰ লগত শৰীৰা সূত্ৰে আমি বলিৰাম বৰা পিতা আছিলে শৰীৰামৰ নামে নামজাৰি
Yes.
name of Boliram Bora has been recorded in the records by the year in 70.
But then,
Then
no, you see this Hukumate Patadar, 2 বিঘা 1 কঠা 9 লেচা মাটি কৈদতে মানি কালিৰ পিতা সোয়েন্সৰ নামদারি হয় out of this 1 kata 14 leches is sold to Boliram Bora.
sold to Boliram.
That is 1 kata 14 lecha.
The suit
Yes.
present. Boliram Bora next sold it to profit. What he purchased.
Just a moment. Yes.
Boliram sold it to Kapitullah. It said it, that is 11/4/1973. On the with the city, which the plaintiff purchased the land from Kapitullah. Very that part has been.
What is the name of purchase plaintiff?
Plaintiff Kamal Kapitullah.
Kafetullah. No. Lutfur Rahman. Lutfur Rahman, you're not finding it that Jamavadi you're showing from page 51,
His name is, Madam Meet.
later part. Okay.
When Lutfur purchased,
Hmm?
when Lutfur had to have purchased the land, then my lord, at the time of Namgiri, first his name was mutated, then his Lutfur's name was mutated. That is the entry.
On 26th of 1977.
Just now, man. Yes.
26th of 1977. Sold a student to Boliram Bora. Then Boliram Bora sold it to Kapetullah on 11th for 1978. Then Kapetullah sold it to the plaintiff on 23/1/1990.
Yes, just a moment. Ashraf sold on 26/5/77. And then Baliram, Baliram to Kafetullah was on 11.
For 1978.
Yes.
Again, Kapetullah sold it to plaintiff on 23/1/1990.
23/1, 1990.
Executed on 23/1/90, registered on 29.
Executed on 23/1, registered on 29/1. Salary number.
117. And executed as
This is by Baliram to, sorry, Kafetullah to you. Yes.
That's part of them. Was really matter. And Ashraf sold it to Boliram to Kapetullah to me. Then the transaction money really has been. Names, Boliram Bora has been according to the records of right, after his name was recorded. And so far the Kapetulah's name is concerned. His name was recorded and later on and the state wing. Plaintiff has recorded his own name in the records of right. Because matter for sale, for matter nutrition. And it should be in the records. Because that cannot be managed. Accordingly, for recording his name, it is the plaintiff's name. Kapetulah's name.
Yes.
The tax, how the plaintiff has acquired tax. So far it is clarified. Now, one of the facts in relation to whether, narrative regarding position, disposition of the claim. In that case, so. Now,
Yes.
Plain Madam, I have studied that I have acquired the right to the polish. However, in para 6 from the plane, I have studied the cause of action. It was given to the traditional interest of the present appellants. Was in partnership policy. He was looking after my plot of land. Although I was teacher working in the school which is sitting in front of the land. I access around the confidence area. So monetarily, my taking care of my land, it was my contention in the school life. Subsequently, he died after my sons, etc. He with the body. The data is not with land. For the issue has never come. I'm claiming by the you also for person of right to interest in the body of person. Countering my contention. That's original. The defendant has put a written statement. Evasively denied my complaint. Their plea, so far their title for this concern, specifically mentioned paragraph 15.
Yes.
There you go. The key position of the spoken is as the suit land along with other land covered by the Patta in school originally belonged to late Nur Muhammad. After the death of Nur Muhammad, his 5 sons, and Mani, who is the father of the defendant, got in entered and buying your sheep, and their names were entered in the record right. Since then, they had been policing the entire land under the efforts of Chapter number 118, currently in their own right. Now, for the confirmation of the defendant in this part, the street land along with the other lands under their joint plan, acquired by you. Subsequently, they have stated that the street land along with the other land towards the south in one compact and two house in the cell. Next paragraph, page 21.
Just a moment, please, please clarify. This, it appears that there's a flaw in this paragraph 15 of the written statement. Here they say it is submitted that the defendants do not find any reason to reply to the notice so and so. The plaintiff is not the owner of the suit land. The defendants have been occupying the suit land in their own right, title, and interest. They are not encroachers. They are not liable to be affected. No, not that. Yes, this para 16. I'm sorry. Late Nur Muhammad, after death of Nur Muhammad, his 5 sons, that is so and so, who is the father of the defendant, got entire land by way of gift and their names. So therefore, here it says that after his death, they got a gift. No, I don't know. I'm just reading what I'm saying. After the death of Nur Muhammad, his 5 sons, so and so, is the father, so and so, got the entire land by way of gift. I'm asking you because I'm very afraid of ghosts. Correct. That's number one. Now, if you admit that they had their share in the land, then we can examine whether the land could have been sold by one of the legatees of Nur Muhammad, because the land has to be partitioned. If there's a specific share in the land, then only one can sell. Otherwise, it's a joint property, and in Mohammedan law, it is tenant in common.
Position. The big brother. But their plea, there's a different, they have taken two pleas. This one. First, the Sultan falls in their cell. The Sultan falls in theirs. That is the first. In evidence, they have taken the another plea, the selling, which was executed in my favor of the problem. The two pleas has been taken by them. Right of sale. So for the right of sale of Kafetullah, the Sultan, the plaintiff, the right of sale of the sale of Kafetullah is not there. Right of sale, how it has not counted, that has been explained that the Sultan falls in this, in that documents. Question regarding having no right of sale, right to sale. That Sultan falls in their cell, that is why Kafetullah had no right to sell. That is explained by. Now it is their part. Say that it falls in theirs. But in evidence, rather, they have not stated anything regarding that Sultan falls in their cell. They rather say that the sale deed which was executed by Kafetullah to the plaintiff was fraudulent in the manufacture. So far, that part is concerned.
Yes, just a
Falls under theirs or it was a sovereign one.
The written statement, the please that the land falls in the share of Manik Ali.
first three lines.
Yes, yes. Yes.
Region. That has no right. As a church from there. So they have seen their page 8, paragraph, page 16, paragraph 8, they have stated the entry of the name of the patient is the normally performance of
You're reading where? Where are you reading?
Page 16, paragraph 2.
Page 16.
Page 16,
15. 1-6. Yes. The entry of the name him.
control name has been made surreptitiously and must have the government had no authority in the speech. This authority has been explained. One year no authority. It has been my lord explained. In paragraph 16 of that document that the Sultan also has said.
Continuous holiday. Friday, Thursday, 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 Diwali will not be here. Then it go to 30 of 30 January. 30 January.
We will continue in the review also.
I'm not aware of the roster, but
Maybe so.
Anyway, but let it be.
since I no, lies to me.